Mr. Jones. Excellent. All right, I think that's almost everybody. Okay, so today, August 27th, 2026, this is the third meeting for the Organizational Expertise, Retirement, Financial Assurance, Rulemaking Advisory Committee, and it's going to be a humdinger. And just so everybody knows, it's not quite ready, but I'd like to meet with Sarah and Patrick a little bit to discuss I have like, I don't want to, we'll call it the handbook of this rulemaking that I'm putting together, and it will have a lot of this stuff from the slides. And obviously you can just grab these slides. I'll make these slides available. But my hope is that we can use this opportunity, the next 2 hours, to sort of go through the issues as we've sort of discovered them and thought about them internally, and then not necessarily sort of come to a conclusion as a RAC, like, oh, we have option 1, option 2, option 3. Let's just do option 2. I mean, maybe if we have time and if there's like consensus, but yeah, it's going to take almost all of our time, I think, to just get through everything. And so you can refer to the slides, but then I'll also hopefully have a handout that I'll send out to everybody maybe tomorrow. And then give the RAC like 2-3 weeks to sort of get back to me and in terms of their feedback. But we'll get through that. So let's jump into it here. So just as a reminder, it's been a minute. We last met in I think March. We are here to discuss the standards located in Rule 10 and Rule 50 of Division 22, which is the council standards. And I'm going to start with organizational expertise. And as a refresher, the organizational expertise is about the applicant demonstrating that they have the ability to design, construct, and operate the proposed facility in a manner that's actually going to satisfy the site-specific conditions. And we have these things that the council may consider, but this is part of the standard, and the things here are also subject to change as a result of this rulemaking. So one of the problems that we sort of identified early on, and it's definitely was a major concern of Chair Condon, is that we are typically evaluating an LLC. I mean, I would say every single time now, it feels like, but who holds the permit and the project rights. But what we really care about is the people behind the LLC, and then also who's actually going to be doing this stuff, which is typically not the LLC itself. So trying to get to that stuff in a reasonable fashion, without being too burdensome. So what we want to avoid is treating the parent company as the applicant when a properly funded and supported LLC or single purpose entity has been created. But what we want to avoid is allowing the parent company to sort of submit a poorly funded and ill-conceived project without any risk by using sort of a shell company. And just to lay my cards on the table, I don't necessarily think this is a major problem. We've never had an issue on this front. This is simply concerns from some council members who feel like the information that we're given would not allow them to evaluate this standard in a way that would avoid this situation. So it's not like, this happens all the time when we're trying to stop it or anything like that. This is just the feeling like this standard was created to do this, but that the way the information we get would not allow the council to do it in a way that makes them comfortable. Does that make sense to everybody? If you have any questions, I'm going to go kind of fast to get through all of this. So do not hesitate to, raise your hand, take yourself off mute and say, hey, what about this or whatever? Yeah, so go ahead and interrupt me at will. But I will try to stop and ask questions periodically. So what do we want to know? Is the project adequately funded, resourced, and will the folks tasked with building and operating the facility do so in a manner that complies with state certificate requirements? Mr. Diaz. So first I'm going to go through a little bit of some stuff that I think we should do. And this is sort of, I'm going to say, Tom Jackman's approach here. I sort of had to make some decisions about like, based on what we've seen, I feel like this is what should be the case, but you all are totally welcome to disagree. The council may end up disagreeing with my sort of assertions here, but I felt like these are sort of some baseline things that maybe we could all agree on, but none of the material on any of these slides really going for this whole presentation, you should take it as gospel or this is definitely going to be the case. This is all up for debate. And if you disagree with any of this, make a note of it and please provide feedback to that front. But with that out of the way, my sort of take on what applicants should need to prove for this standard is that, first of all, we should focus on the applicant's actual ability to carry out the full life cycle of the facility, but recognize that the LLC will likely, almost certainly rely on other companies to do so, and that and that the council should be allowed to require proof that those resources will be available to the LLC. Okay, and it's more, the substance of this, not necessarily how things are structured. So, which is to say, not to treat an LLC as like inherently problematic. It's just a way of things are done, and we should be able to sort of mold the process to reflect that. And the question isn't necessarily who controls the applicant, but where are the necessary resources located, and does the applicant has the applicant secured access to those resources? Okay. To that end, I think it's fair to. Oh, and here's Cindy. Perfect timing. Perfect timing, Mrs. Khan. We're just getting right into it here. So these are the things that I think hopefully we can all agree on with respect to organizational expertise. Okay. But yes, good to have you here.
Well, sorry about that. I must have had a different link. I was waiting to let in. So we're good. Yeah, thank you.
You're here now.
I'm here now.
Right on time. So I think it's fair to say that the council should be looking for a complete control, ownership and control chart that shows the ownership chain to whoever's ultimately controlling the applicant, right?
Yes.
And it doesn't matter, in my mind, it doesn't really matter if there's how complex that structure is. We just want to know what it is. So yeah, and then sort of the role that each relevant entity plays in supporting the project to the extent they have a role. So yeah, it's really just about knowing who's controlling the marionette, if you will. And then the applicant should provide operating agreement, bylaws, anything that would be relevant to understanding this structure and the power of the decision-making authority and whether the applicant itself has the authority to enter contracts, receive support, whatever, in a manner that would be sufficient to satisfy the certificate obligations. And it's not necessarily that we would require an operating agreement. It's just about ensuring that whatever governing documents and agreements do exist establish the sort of necessary authority, capital obligations, whatever, that would allow the LLC to access parent or affiliate resources. Yes.
Do you want questions or later?
Yes, absolutely. You missed my preamble. We have a ton of material to get through, so I'm going to go fast, which is to say the time to raise your concerns about this slide is right now.
Okay.
So if you have any issues with any of this, raise your hand.
Okay. Okay. Well, go ahead, and when you're finished with the last one, then I'll.
No. Oh yeah. No. That's it. I'm done on this slide. So if you have a thought about what you saw here, go for it.
Okay. I just want to say that I believe the operating agreement is important. Partly for what it says the parent company is not responsible for. And who is the parent company at that point? Is the Next Step LLC or the Next Step LLC? I mean, how does that chain, that chart will inform us how many LLCs are in the chain? But an operating agreement would tell us what the parties have agreed to in terms of financial responsibility, all of the things that we're supposed to find expertise and have confidence in. So I just want to, and we did talk to, an applicant's attorney early on, just informally, and he maybe didn't suggest, but he mentioned the operating agreement, and so that's why I think it's important.
Okay.
Yeah,
Go
I'm completely
ahead.
the reverse and think that we would highly oppose that. Like that's getting into. Are you starting to do background checks on what our rates are with bonding agencies and etc. Like it's getting. I don't know. I'm going to oppose that, especially the operating agreement. Vastly. The org chart's one thing, and being able to list off how we utilize affiliates, but I'm just saying that I'll oppose anything that starts to where you're having to provide the council business related, very specific business related items. So I'm just telling you where I'm opposed.
And I fully expect that. So, it is not a surprise. I am trying to find evidence that an LLC at the time that we are asked to approve the facility has the capable, and I don't have anything. So that's kind of what I'm after. So you can certainly inform me about what takes the place of that.
Mr. Bauer?
Yeah, just a curiosity question, and maybe you're going to answer it later, but just curious if this is going to apply to non-LLC type situations where there's an exemption or something written into the rule for those of us that don't operate under LLCs, either construction and or operation, that we won't have to go through this process.
So we'll get to that in a second. This slide specifically where sort of ownership, control, and governance is an issue because the applicant itself is not asserting that it has the resources or the finances, and then it's relying on something else to it basically. Just wait one slide, we'll get to it. But yes, it's not necessarily
I'll patiently wait, Tom.
Yeah, okay. I did tell you to interrupt me as we want, but yeah, we are definitely going to get into the weeds a little bit on that on the next one. Miss Crowley Coke.
Yeah, thanks. I want to agree with David's comment that we want to make sure we're not exposing confidential business information unnecessarily. And then I think it's important to make sure we're streamlining as much as possible and having the information that is required in 1 or 2 documents, not 5 separate documents that repeat information. Thanks.
Yeah, I think definitely streamlining is going to be hopefully a part of this. And then also one of the reasons why we did this with respect to the financial assurance is that there definitely is some overlap there. And so to the hopefully the end product will be identifying anything, even just between those 2 standards, that if there's any duplication that you would be able to, we would either strip it out of one, or to the extent it was sort of relevant to both, say that submission under one standard would be sort of, you could cite that for the other one. You would need to submit it again, if you will, in another form. Yes, Ms. Condon.
Yes, I disagree with that a little bit. That I see financial assurance as very, very separate from this standard, organizational expertise. We're assessing an applicant for developing the project as it is represented. The financial assurance is a factual piece. You can't start construction until the financial assurance, the bond, the security is provided. They are not the same. And so I guess I'm not really sure why we'd strip out one for the other, and I don't think they're redundant. So.
I mean, we may not, but I'm to the extent that we do identify any duplication, then I would suggest that we don't require people to submit the same thing in more than one place.
All for
We-
that.
Yeah. Okay. So let's get into this a little bit more. Oh, Miss Esterson.
Thank you. I just wanted to offer just a small point of clarification on the overlap. So the organizational expertise has, the standard itself has like 3 prongs, and one of them is that the council find that the applicant has the ability to restore the site to a useful non-hazardous condition. So right there, the organizational expertise standard overlaps with retirement and financial assurance. And we always punt those findings over to retirement and financial assurance. So I think that was the space we meant there was overlap. Like, let's make sure that nobody thinks you have to evaluate the same thing in 2 places.
Yeah, and I just to speak to that, I understand that fully, but what we are getting is certainly not evidence of much. And so, if we can strengthen that on the front end, I don't know how we would do that, or what it would entail. And certainly we have the factual of the assurance in place, the security in place, when it's construction time.
Yeah, although we'll get into that too, as you'll see here, hopefully. So my thinking is that we sort of just create the concept of a relied upon entity, and it doesn't have to be a single entity for all functions. You might rely on multiple entities. As an LLC, probably specifically, you might rely on one for financial support. You might rely on another entity for engineering expertise. So, we just require the applicant to identify exactly who they're relying on, or what they're relying on each entity to provide, and then require evidence that each relied upon entity possess the claim capability and the obligation, or that the entity would be legally and practically available when needed to do the functions that the LLC is relying upon it for. I don't know. Does that make sense to everybody?
Yeah, if the LLC has the financial strength to contract with those companies.
Sure.
I mean, give us something that says, yeah, you can go out and find these and hire them with, but we don't have any financial information, obviously. At this point, we don't.
Sure. Yeah, and then I do think it's important. I mean, just based on my own research on what other states are doing, basically almost nobody has a requirement that there's a guarantee from the parent company. It's not to say that we couldn't do it ourselves, but I do think, it's not crazy to require some sort of services agreement or capital support agreement or some kind of instrument that indicates that there is a sufficiently, specific and enforceable obligation by the parent company to support the LLC, to the extent the LLC is saying, well, we don't have this, X, but our parent company does. Okay, great. But does the parent company have to provide that for you, or what would stop them from just pulling out down the road? Not that this has been an issue, but I do think this is, correct me if I'm wrong, Chair Condon's concern is that sort of in the absence of that evidence, then it's not clear that the LLC actually is meeting the requirement. David, go ahead.
If it's not been an issue, then this gets into a whole bunch of things, including the financeable entity is the LLC, but it's only after you actually build the asset, right? Because that's what the LLC will eventually own. And that's what we finance. We finance the LLC. That's how we do our financing. And you're getting into, reliance letters and we are trying to create an entity that at the end of the day can hold, let's call it $500 million of assets, finance those assets. And at the very start, when we're doing it, you're right. It is a smaller entity. We're not saying that the parent company will, our parent company tends to, not only, but we tend to finance during construction from the balance sheet. But I don't have a specific agreement that shows that. It's just that's how we build it. We could also go out for financing to build, which a lot of other companies do as well. So this, you know, when you have reliance and reliance letters, and, you know, there's going to be a lot of paperwork that actually, I don't know, it seems really into the weeds on something that when you have you're not going to get financed if you don't have the expertise and you don't actually have an asset. And I know that sounds like, oh, well, that, you know, you're leaving that for later, but that's the facts.
So
So I'm just very much like, it just seems like you know, you're trying to solve for something that hasn't been a problem or isn't a problem.
Well, we're kind of in a new world of energy facilities. You know, I realize others have been dealing with it for a long time and have experience, but things can change in an instant. And we are providing a certificate, or want to provide certificates that are based on good evidence. So it just, you know, if not this, then suggest something that we can sign our names to a document and feel like we had the evidence. But right now, there's not a whole lot there.
I just wanted to chime in that I think what we're talking about here is that it is really difficult to get to this stage where a project is applying to EFSC. If you don't have the financial capability to do the project, you're not applying to EFSC. And so that's, I think, why we're like, well, if there's not a problem, why are we trying to fix something? Because from our end, you know, the finances of these project is the biggest part of the project. It's not, you know, counting solar panels and design, it's the financing. And so if you don't have that, you're not putting in all the effort and money and complexity of applying to EFSC, period. If a project, you know, doesn't have the stability and the financing and the expertise, you don't see those projects. They don't come your way. So that's why we want to make sure, you know, you have the information that you need, but we're not going overkill, recognizing that it takes a lot of work to get to this point to even come to EFSC.
Yes, I certainly appreciate that. It's just pretty opaque to the council, other than we realize you have financing, and when you apply, you are applying to certainly do a project, but it's pretty opaque for us. And what we're asked to do is make the decisions on evidence. So anyway, I'm trying to get pieces of evidence that at least have some strength, that build confidence for us and the public. We've already had questions about who these people are and what their financing is and where it comes from, and we don't know that.
So one of the things that yeah, that I'm suggesting we do is, and again, this is just my suggestion, is that we would allow preliminary agreements during the application review with sort of a firm hold point before the capability would be needed. So essentially make it a mandatory condition rather than an application requirement, because obviously, right, the point at which you would need those, you know, resources, you will have them, and then it would be easier to actually establish that, right? And it would still be a situation where the council could be, you know, say, okay, we're comfortable with this, so you can proceed, but we're not asking for it or saying that we care about it at a point in the process when it doesn't really, you know, exist, and therefore cannot be shown. So these are all just things I want people to think about. And obviously, you know, we've David's expressed some strong feelings about this, and I would hope, to the extent that, especially after we sort of get into the weeds a little bit more, Yeah, I mean, absolutely. We like this one because of X, and we do not like that one because of Y. So that's the sort of stuff that will be the most useful. I'm gonna proceed here, and again, this to the extent I sort of skim by any of this, I will make this presentation available, and then I'm also gonna hopefully, I think the presentation will get you most of the way there, but I'm gonna try to get something that's a little more comprehensive that people will be able to review, like with your legal team or whatever, to provide thorough feedback. Um, one option I was hoping we could consider is just requiring a sort of standardized project history table instead of what we get now, which is sort of an open-ended narrative a lot of times, which makes it kind of hard for staff to review or compare. We get these narratives and it's like, well, I don't know what I'm supposed to do with this, but looks good, So sort of making this, to the extent we do care about it, sort of a more discrete, focused, information submission, more of a checkbox, if you will. And then the people evaluating these will have a better sense of like, okay, looks good. And then, making what we ask for sort of proportionate to the project itself. So we're not necessarily saying like, oh, give us the last 10 years of everything you've ever done and your parent company has been involved in, and there's like, 1,200 projects or whatever. We obviously don't care about that level of detail. Yeah, I mean, I think the information requirements have to be proportional to the project. So to the extent you have a massive, enormous project, then there should be sort of evidence that sort of a project is that you have the organizational expertise to execute that level of a project. Okay, so I think we should be focusing on, objective project outcomes. So, it's when we're looking at the history. So obviously, there could be situations where project receive approval but not completed, but it's not necessarily, due to sort of malfeasance or mishandling. There could be all sorts of reasons. Maybe there ended up not being any room on an internet connect queue, and eventually, no hope of ever getting any room, and so a project might get abandoned, for example. That's just throwing it out there. So, but we do ask for and are presumably interested in understanding, why an applicant might have multiple, projects that were abandoned or failed. But we wouldn't necessarily treat that the existence of an abandoned project would, it's not like, well, okay, that's an automatic, fail or whatever. But yeah, just sort of it would just sort of be evidence that would be considered as part of like the totality. Miss Condon, I'm seeing lots of thoughts go through your mind.
They've gone through my mind for a long time, but
yes,
I would agree with that. For the most part, I think that history is important for a variety of reasons. We don't have a need standard, but we are essentially setting aside or providing a certificate for larger and larger projects that if they don't get built, and council has spent a whole lot of time and effort in reviewing and provided the certificate, that in my mind is a problem. So I do think the reason for abandonment is important. And I think you're absolutely right, because a project was abandoned for a good reason certainly would not be grounds for rejecting a project. For me, I can't speak for all the council, but I basically agree. I think that information is important.
Okay. Ms. Beyer.
I didn't have my hand up, but since you called on me, you may have been looking at Andrew, because we have an AB and an AD. But the historic information is important, but again, not a stopper. I like the idea of coming up with almost a checklist template so people don't feel like they have to provide too much information. I think part of what council struggles with is in organizational expertise. It was designed for a different world where not all the projects were LLCs. We're seeing a lot more transfers of projects between entities. So I think what we're trying to ensure is that the projects that we consider for approval and ultimately approve are actually built and built by people with the competence to construct, operate, and reclaim. And that's going to be the common theme. It's not to put additional burden on the applicants. It's just to help us understand your world and what kind of certainty is probably too strong a word, but information, evidence you can provide to us in making decisions. So what I'd really ask from the other folks on the RAC is to just tell us about your reality, because we aren't there. We don't know about the financing structures and the relationships, and we don't want to get into confidential business information. Really, we just don't. But knowing how you're organized, knowing who ultimately is responsible for the projects we approve getting built is kind of the goal of this. So that's my 2 cents, but help us understand your reality. If you don't like some of these proposals, give us something else. So thanks.
Okay. Any, I saw a hand go up and go down, back down. All right, I will move on. So I do think it's important to have ongoing disclosures. You know, some of these processes can take years, and you know, significant changes can take place with the LLC structure that would, you know, might cause sort of a material change that would change how the council would consider the application. So, you know, that could be a change in services agreement, you know, a key contractor backing out that you were previously saying you were going to rely on, you know, a parent commitment that doesn't exist anymore. Maybe the parent company sort of sells the LLC to another entity. I don't know. There's reasons why you would want to update this, and of course, if nothing had changed, then you wouldn't need to do anything, right? You could just say nothing's changed since our last thing. So this would just be a requirement that if something were to change, that would be material that there is an obligation to make sure the council's aware of that. Okay. And then obviously confidentiality is important. So I do think, you know, I talked to our Secretary Cornett about this, and who's, and you know, the feeling is that we would just sort of follow, you know, Oregon Public Records law, but doesn't mean we can't sort of have a process for how we would do that. So people are sort of understanding, you know, we could have a, you know, a defined process where folks are concerned about confidential business information, you know, allow them to submit 2 copies, and you know, one of them that's redacted that we would share with the public, and an unredacted one that the staff could review, and then we can make a determination after the fact if we agree with the legal basis, and sort of you treat it the same way we would any other public records request, you know, have DOJ review it or whatever, not to necessarily create a new exemption process, but just a process whereby we could keep the ball rolling, and allow for folks to protect information if they feel like it would be protected by Oregon law. So I don't know if anybody has any thoughts on that one. I don't think that's gonna be too that's what I'm looking for.
Tom,
yes, go for it.
Just a comment about that. And I fully agree with, we want to keep confidential information confidential.
Controversial. That's the word I was looking for.
Oh God. Okay. No.
Yeah.
But I do, what the council has seen in evidence provided is this these statements of confidentiality that certainly the attorneys have provided, saying yes, this company is good to go, essentially, but what we're telling you is confidential, and that also on financial documents, and that is not satisfactory. So, you know, you just can't claim confidentiality because your consultants or providers have said that the applicants' providers have said that. So this is an important piece. We don't want to violate confidentiality, but we don't want applicants or their advisors to claim confidentiality when it doesn't work for what we do.
Sure, and we have language that we just recently introduced as part of our compliance rulemaking, which essentially says what I'm saying here, that the applicant would need to identify, you know, not just saying like, this is all confidential, but like this portion is confidential and it's confidential under this statute or whatever. And then we could review it and, you know, agree or not. But yeah, not just letting people just wave their hands and say confidential, everything magic, you know,
Right.
whatever. Okay. So just to conclude our discussion on the organizational expertise, I do think sort of my take on Chair Condon's thoughts are we don't want to just allow people to essentially say, you know, someone in the corporate family has experience, so we're good to go. And rather we want to be able to, the council, I feel like, wants to be able to say that we understand who's going to perform each of the functions that we're requiring of the certificate holder. And we know that whoever's going to perform that function has the capability and that the applicant has secured access to whoever they're relying on. I mean, that's really all it is, right? So we're requiring you to prove that you can do A, B, and C. You're saying that you're going to rely on X, Y, and Z to do A, B, and C. Great. Can the thing you're relying on do it? And can you show that you actually have access to whoever it is that you're claiming that you're relying on? So just linking the capability to the entity, to the applicant, with evidence that is more than just, you know, your own statement that something is the case. Would that be sort of saying it correctly, Chair Condon?
I would say so. We have asked for and relied on evidence that is not very meaningful today. And so how do we change that to meaningful information? I think you've captured it and what we're trying to get to.
All right. So again, I will have these slides for people to review. I will also have, I'm fairly certain I will be able to provide folks with sort of a handout initially titled RAC homework, but just sort of like where I lay out each of these issues in just like a memo format, and you can just sort of review it and go over these in more detail. So let's move to financial assurance. And we're actually making pretty good time, although financial assurance, there's so much. It's actually bonkers how much we could discuss. And some of this I'm going to breeze through and really just say, you know, think about it down the road. But yeah, at the end of the day, it's like, it's not that complicated. The council has to find that the site can be restored to a non-hazardous condition following cessation of the operation. I mean, that's it in a nutshell. But how we go about establishing that, I think, has been a bit of a challenge. And this is where there's enormous variation in what's actually done. We found this cool report by a research institute that goes through all 50 states on how they establish the financial assurance standard for energy projects, for solar in particular. And literally all of them are different. There aren't any where it's like, oh, Nevada and, you know, Idaho do the same thing. No, every single one of them is sort of a slightly different than every other one. And obviously there's some overlap and similarities, but yeah, which is to say there's no there and frankly, there's not a lot of evidence. There's only a couple of like solar facilities that have been retired, or like there's a little bit more with wind facilities. It's kind of an older technology, and there's some older stuff that was not repowered and brought to end of life, but not a lot. So how can we show whether these estimates are good? And even if you looked at the data on those projects, would that make you confident that an estimate of a project being built today and decommissioned in 35 years would be accurate? I would propose no. The answer is who knows things are going to be like in 35 years. So this is all about choices. And what I'm looking from the RAC is sort of, what do you think is reasonable? And given all the unknowns, and because it's sort of like, we can make things really easy, but not very accurate, or we can try to make things accurate and fair, but it will be sort of more complicated and costly and not necessarily ultimately be accurate in the end. So yeah. All right, let's get into it. So yeah, the existing system, I would say, is based on our analysis, is fairly protective of the state, but it's not really transparent. It's not really efficient, and it's not really consistent. So we sort of get different things from every applicant, and our analysts sort of don't know what to do with it. And we do the best that we can, but this is an opportunity for us to sort of create a unified approach that is fair and consistent, and provides the staff with the applicants with the tools they needed to efficiently provide this information consistently and understand exactly what they need to provide. And say, okay, we need to produce these 3 documents, we need to check these boxes, and then when our analysts get it, they can be like, cool, you filled out the stuff, the boxes are checked, council can look at it, great. So yeah, the goal isn't necessarily to magically solve the problem of how do we get an amazing estimate that's always right, but really, in my mind, it's how do we reasonably feel comfortable with the estimate we're going to require people to generate, and do it in a way that is repeatable, consistent, and fair. So here we go. So right now we ask for sort of the bond. It's never really revisited, and that's an issue we'll discuss here later, except for inflationary adjustments. And there's a whole bunch of states that are more aggressive about using like graduated bonds to sort of reflect risk at various points, rather than just say you need the whole thing at the beginning and then that exists until it's needed. And then we ask for folks to justify methods and assumptions, but we don't really ever get what we need from that. And I think part of that is that we're not specific about what we're asking for. And I think we either don't ask for this, or we ask for it in a way that ensures that we get what we need to evaluate.
So Tom?
Yes, Chair
question?
Condon. Yes.
So, and I apologize, I think that's the first time I've ever heard this, but so when you present to council, and we've got the information in our material, are you saying that you often don't get what you need? And so it's not factual as it's coming today? Is that?
No, so I mean, people say, we get different justifications for methods used, and we get different assumptions about labor costs, and they're sort of all different, but we don't provide staff with like, okay, here's how you should evaluate labor costs. Do we care that do they have to provide labor costs? And if so, how, these guys say if they're estimating in 30 years labor is going to be $100 an hour, and these guys say it's going to be $50 an hour. Like how would we evaluate that? Like, so yeah, trying to just create a it's just sort of like, for all of this stuff, we should only be asking for stuff if it's useful to make the evaluation. And if we're asking for it and then not really using it because we don't know what to do with it, then we should either not ask for it, or we should determine a methodology whereby we either know what to do with it, and And the only way we're going to get there is if we ask for essentially the same thing from everybody. If we're consistent in the requirements in what is submitted, so that we can then train folks and say, okay, we're going to ask for this type of information, and when you get it, this is how you're going to evaluate it.
Okay, and then
So-
quick question on the previous issue. They are revisited anytime there's an amendment.
Sure, but
And
absent an amendment,
then
yeah,
it
we
is
only
just-
adjust it for inflation.
Yeah, okay, thank you.
Okay, so I'm gonna so then there's also some concerns raised about the flat administrative bump and the decommissioning contingency bump, and we'll get into that later. So we'll get into this here in a minute. So what do we want? We want a reasonably accurate estimate of what it will take and proof of adequate funds to do so. That's all we want. So how are we going to get there? Yeah, as I said, there's 49 other states and there's 49 different ways to sort of package this. So what should we do? I do think it's important that we require transparent disclosure of major assumptions, and that we should be asking for sort of the same assumptions from all applicants. So, if we care about labor rates, then we should ask for everyone to submit their assumptions regarding labor rates, removal depths, whatever. If we don't care about that stuff, then we should let people to know to not waste their time calculating that, right?
Tom,
Yes.
sorry, question.
Nope, go for it.
For things like removal depths, and this has always been somewhat difficult to me, is I'm not really sure how, what the definition of is reusable condition, return it to a usable condition, and how that overlaps with landowners' requirements of the applicant or the developer. And so like removal depths, do we have our own and the landowner have theirs, or how does that work?
It's a great question. And to be honest, I'm not entirely sure what the answer is or even should be, partly because, there's different ways to argue it, right? So there's different crops, some of which require greater depth than others. So are we saying the land has to be usable for any crop you might ever conceivably plant there, and therefore you're going to need to go that much deeper? Or is it this was likely ever going to grow winter wheat or whatever, and that only needs to go this deep, so that deep would be sufficient? Yeah, there's different ways to look at this. And do we have a way? I don't know. Sarah, do you want to answer that question?
I don't know if we have a way, but it's sort of like an accepted assumption of a 3-foot foundation removal depth. I think our concern though is that it's not really it's not in the rule. We don't have current guidance policies, so that if that is our standard, is it accurate? We have had, just as Tom said, recommendations sometimes that kind of come in that are like much deeper, and we're like, wait, what? Like that, it's a pretty expensive change. And so it leaves us going, what's the best way to figure this out? And we have not done the work to, establish anything different than 3 feet. And again, I don't know if all applicants, especially new ones and new consultants, know that.
So how about, is there anybody else in the call that would kind of know how those are established?
Yeah, well, it is done by steps. First of all, let's go back to landowner. In all leases, we, the developer, have some amount of specifics in there about certain things, and depth is one. The other one is that we leave cable, just like utilities do, by the way. They leave that in situ, right? Cable at 3 to 4 foot depth. It varies slightly depending on soil type and other things. And so, there is a general standard across every jurisdiction I've ever worked in. It's 3 feet unless we have either a landowner or a very specific reason to go slightly deeper, and it's usually only slightly deeper. So I'm just telling you that standard has been set up. It's actually should be quite known, of at least on the wind side. And as far as solar, I believe we mostly take the racking out. We yank them out. So, and it is part of a lease. And again, you don't know that, and you don't actually technically need to know every detail of the lease as well. But rule of thumb, I think the best way to do that is just disclose what our assumption is in our remediation plan. And we as an applicant would tell you. We are planning on, when we decommission, we're planning on going to 3 feet. Or in these circumstances, we're going to 4 feet.
And the
and
assumption,
we're leaving cable in situ and those types of things, so that you actually know what you're. And I thought in our remediation plan, we do have some of those items in there. It
Sure,
is
you might.
generic because it's
Yeah.
I'm just saying, it's a little bit more generic at the start, because you're like, okay, but it's depths and what you're doing with the various materials is in there. And so anyway, that's my thought, is that we would just disclose. We disclose what our assumption would be, and that's what we're assuming when we're also providing you the bond or the LOC.
and thank you for that. And I get one of the things that I've often questioned or wondered about, really more than questioned, is if there were differences between what we were basing it on and then what the landowner really had in their contract. And so that seemed to me to override. So let's just say if the landowner said, well, 2 feet is fine, and we're figuring 3 feet, would you correct that and say, we have an agreement that 2 feet works?
Oh, you're muted, Davis.
Yeah, I saw that.
No worries.
Still, after all this time, I still
I still do it
as often.
Part of the reason the question is
yeah, I think I know what you're saying.
Yeah, I mean, should we look at 3 feet as a?
Should we setting minimums, or should we allow landowners to sort of override that? I'll just throw one thing out there.
Yeah.
I know, I can't remember in the context, maybe Patrick can, I don't know if Patrick was involved in this, but I remember there was a situation where there was roads that were built and the landowner was fine with leaving the roads on, but then there was a decision made that the roads had to get pulled out, even though the landowner was okay with it because it wasn't restored back to whatever the, usable farm, whatever it was previously. Anyways, sorry, David, go ahead.
Yeah, you hit on two of the things exactly. If you just have the thing as part of the disclosure, the developer will tell you, and we're not going to put in there that it's 3 feet if we might say 2 to 3 feet or 3 to 4 feet, depending upon lessee's responsibility. If it's just that we need to disclose to you, then we'll disclose to you what our assumptions are in our decommissioning plan. I think, honestly, that is the best, and including some of that language around, unless landowner, wants to keep roads and or lay down areas. I've now only been part of two decommissionings of particularly wind farms in my career, and in both cases, several landowners wanted the roads left for harvesting. They start using them for lots of reasons, and particularly sometimes take out up to this amount, and I want to keep that nice graveled plot there, and that we can do when we decommission, because there's also language in the leases and other things that we have to sign, get them to sign off on when we finish a project.
Thank you.
That's my thought.
Thank you. And it was the roads we were talking about, a depth, but it was the roads case that where the landowner had said, no, I'll use the roads, and how that was developed. That is what I was unsure of, but I know it was certainly disclosed. We knew it as council that the landowner had wanted to keep the roads, which was good because it was in the record. So thanks.
Okay. So I get, what I'm looking for from like RAC members is, what assumptions should we be asking for? Do you agree that we should be asking for the same thing from everybody? And obviously in some cases you might say, well, we're asking for the same thing from everybody, but it might not apply. Great. I mean, in that case, I do think it would be appropriate for people to respond, okay, not applicable here, whatever. But at least we're sort of starting from a baseline. So I do think it's important, and we don't really have any sort of qualification requirements about who's preparing the estimate. So there's some sort of questions around that I want to get into maybe. And then I think it would be helpful to require updates when the facility materially changes, which we're not doing right now. I suppose we're doing it in the sense that there is an update when there's an amendment, but like what we're looking for, the particular instance I'm thinking of is we're now creating a new administrative update process in the compliance rules for a facility as built. So if things don't get built, then you would think that you would. I mean, we're now going to be updating the certificate to reflect that. In my mind, we should be also updating the bond to reflect that certain things didn't get built, right? So that the bond reflects the actual structure and what the decommissioning cost would actually be, not what the maximum initial application for that certificate was. Sarah Esterson.
Yeah, I just wanted to clarify, so the council, when at the application phase or amendment phase, the council reviews an amount for a full project, but then the conditions that staff present for council to review associated with the site certificate allows for that bond amount to be based on what is actually built. So we don't ever have a situation where we're sitting with a bond that's more than what went forward at pre-construction as the final design.
So we may want to put that in rules, but we may also not. I mean, obviously it's been working fine as it's been going. So we don't necessarily need to have everything like that in the rules, but it may be helpful to sort of indicate that that's what's happening and that is.
Yeah, I mean, I think it's a good point that it's not clear. I mean, potentially it's not clear to everyone that even though the bond is approved or the amount is approved at an amount, but the condition allows a reduction based on what's actually built. So fine with that.
Well, and the rules are a reference point, right? It tells them what they need to do. Change the facility, as opposed to afterwards when you're reviewing and going through the numbers, right? I mean, it tells somebody before as they're thinking about a change, what they'd be required to do. I think it would be helpful in rule.
David?
Yeah.
Oh, sorry.
I don't mind.
Someone else was trying to talk. I can't tell. 541-805-8446. You're real quiet if you're trying to say something. Okay, David, go ahead.
Okay, yeah. My don't mind it being in the rule, but make sure it's very clear. Like that's something we don't miss very much when we're an applicant. If I'm only building 200 megawatts and it's a lot smaller than the original amount, we don't usually miss that reduction. And also certainly ourselves and many others, we of course permit, as we've talked about, we permit to this size, and we often go through several amendments to bring the next phase of the project through, and then you would only be bonding for the next phase of the project. So this isn't from our perspective the biggest of the issues that you're bringing up.
Yeah, sure.
it does work its way through.
Okay. So I do think like the current rule requires that the applicant is reasonably likely to obtain the proposed bond. But we often end up getting information that we then have to request a refresh for later. So I think we should sort of standardize the information used to demonstrate that an instrument will be available so that we don't have to go back to the applicant. And then let's see. Yeah, there's some stuff in 50 that I do think that just isn't needed at all. So, I mean, right now there's some stuff about industrial materials that aren't necessarily directly related to financial assurance finding and could potentially be addressed in like our waste minimization, or is just like a cross reference to another standard rather than keeping it within retirement financial assurance. This is just a thought I'm having that I think is worth exploring. Okay, so now I'm entering the section here where I'm going to sort of maybe rapid fire some options for how we might go about doing some of the things that I was discussing. And we don't necessarily need to select those here, but I just wanted to raise them. And then hopefully, again, you'll have these materials to review, and then you can sort of go through this. And then if you have feelings about us picking one over another, that you would then let us know. David?
Just one comment on the previous, this is good.
Sure.
Go through pros and cons, all
Yeah.
that. But on the previous portion, you said that not all applicants, you have to have the same, like we've used a similar instrument going to one of our bonding agencies or one of our LOC and just getting a letter saying, yes, they could get the instrument if needed. Just make sure that you're like you've done with your standard, because I know you have many standard bonds and LOCs.
Yeah.
Make sure it's like, this is the types of information that we would need, and make sure it's, broad enough that, yeah, there might be individually, because we might bank and do things slightly differently, but that, yes, the end result is we could get a bond is what I think this is leading to, right?
Yeah.
A bond or an
Obviously,
LOC.
you don't need it until you need it. So you're not going to be able to, there isn't going to be a document necessarily that exists that says, here it is, until you actually get the certificate, and then you would then get the bond. It's just that we end up getting stuff that like becomes outdated. Maybe it's only good for a certain number of days. So I don't know if there's something where we could figure out a way to standardize what's being submitted that makes this process easier. Maybe not. Maybe this is sort of that we're already doing it the best way that we can. But this is just an area that we identified as sort of annoying.
Yeah. And it might just stay annoying just because
it might just stay annoying.
No, I'm just saying that because I know we have a process, but that's just us, right? So yeah, okay.
Yeah. And here's the thing is that if you've been doing some things and you're like, oh, we totally like how things are doing, great. But if that's the way if you like the way things are going and you don't want them to change, then maybe we should and we're trying to sort of formalize our process a little bit more. Let us know that you like how things are going, and then maybe that's the way we formalize it, the way you're sort of already doing it, so that other folks are also doing it that way. Yeah. Chair Condon.
Just a comment about I personally, I don't think the comfort letters as we receive them really provide much. And as a council member, I really rely on the protection of having to have the bond to go forward. So if there were another way other than a comfort letter to provide evidence that surely a bond would be available, I don't know whether the parent company, says we have the resources and whatever, but, a letter from a bank, the letters from the financial institutions have been, I think, really inadequate. So if somebody has a suggestion
Well, I mean, I don't know. I sort of feel like it should go the other way to the extent that it's sort of not, the evidence isn't really that great. Maybe it's because there really isn't good evidence out there, and therefore we shouldn't be asking for it. And it should be sort of more of just like a mandatory condition where, I mean, we already have the compliance rules, again, to just go back to them. We're sort of strengthening that in our current proposed rules. Public comment period to end at the end of September for those who might care about this issue. But it specifically says that to the extent a condition applies to a component phase, whatever, that a certificate holder is not allowed to proceed with construction until they've demonstrated compliance, and then the council has sort of said, okay, you can now proceed with this, whatever it is. So in my mind, like with the extent that a condition would be you need a bond for whatever, we can still, the protection is still there, right? You can still say, okay, they don't give us anything now because there's not really anything to give us, but you still can't start construction until that bond exists. So, okay, great, you have a site certificate, but you didn't get the bond, so you can't do anything with it.
Right. That is my point, is that the condition is the bond.
Yes.
And so the comfort letter doesn't provide much.
So maybe I'm saying maybe we don't ask for anything at all because it's sort of pointless.
That is an option. Yeah.
I mean, I'm just throwing this out. Yeah, that's just something to consider. I'm not dying on that hill, but
I sort of throw that out.
Yeah.
Or because I think we talked about that before.
Anytime we ask for stuff sort of before it's really available, it sort of suggests that maybe that should be a mandatory condition. And then anytime we're asking for stuff that we don't really know what to do with, we should ask ourselves, why are we asking for this? Should we ask for something better, or should we just not ask for this at all? So that's sort of my thought process on all of these standards and the information requirements. Okay, so yeah, I'm going to run through a couple of different areas, and I did sort of more or less, some of these I have more details on the pros and cons than others, but yeah, so the first area I want to go through is the sort of calculation of costs, which is kind of the biggest one, sort of overarching main goal of the standard. And the way we're doing it now is we sort of have project-specific estimates, but one option would be to sort of standardize the disclosures. So we would have basically a form that you'd fill out, so there'd be like a required format that you would require you to specify certain things, because right now it's sort of open-ended, like, hey, let us know, figure out how to calculate it and tell us why you did it that way, which has its own strengths and weaknesses. We could switch to sort of a formalized fill out this form, and it would specify exactly like X hours, and our assumption would be $80 an hour or whatever, so that everybody would submit kind of the same thing, and we would get the same information. We would evaluate it in the same way. And I think sort of the pros for me in this one is it would preserve the kind of the flexibility for, different sites, different technologies, and it sort of places the primary responsibility on the applicant to sort of figure out, you're providing the assumptions, you're providing, you're basically doing all the calculations and figuring it out. The con of this is that, and this is sort of what we've been getting, because this is largely what we're doing today, it would just be sort of maybe formalizing what's happening today, is that we get wildly different stuff from everybody, and we don't really know what to do with that. Like, this one's twice as much as that one for the same megawatts. Was the other one unreasonable? Or is this guy overestimating how much it's going to cost? And obviously we're less concerned with overestimates, but when we get sort of wildly varying estimates for similar projects, it does sort of make us think, like, how do we evaluate what's reasonable, what's not reasonable? And obviously there can be a range. It's not like we're looking for a magic exact number, and if you're off by $1, then that's a problem. But you get what I'm saying. Like, is there a way we could do this in a way that would lead to more consistent results? And maybe the answer is no. But this is how things are sort of operating now. And if we're And one option is to just be comfortable with what that will lead to. I'm going to power through some more options before we maybe have a discussion on this. Option 2 would be to develop a sort of state reference framework or a component-based cost model where we sort of establish, it will cost this much to, and we have tried this before, where we sort of did establish a reference, but and it was great, provided an objective baseline, promoted consistency across projects. I think it did reduce the cost for applicants in preparing and reviewing us, both to submit and for us to review. It was cheaper. But the problem was we have to continually update that, and we didn't. And the question is, like, do we have the capability to do that? Is it reasonable for us to sort of continually update that? And I don't necessarily know the answer to that question. And I do think determining the proper, like, if we do come up with a static framework that we sort of develop ourselves and everyone has to use it, like how, figuring out exactly how detailed that will be, that should be, so that it works across all projects. That's also its own challenge. And then obviously, if we're going to say, here, you have to use this, then some applicants are going to be unhappy with, like, assumptions that were made by Odo, who prepared the thing that you have to use. It says, okay, here are the assumptions we're going to require you to use. So I don't know, Sarah, if you have any thoughts particularly about this one, particularly since we did sort of try this. Do you have, I'm curious if you feel like this is worth pursuing, or if based on our previous experience, you feel like it's not worth pursuing. I don't know.
Yeah, I guess, I'm like almost at my 12th year here. And when I started was when we had decided the model, and it was this Excel spreadsheet that had been prepared by a consultant that had multiple tabs and all the, unit costs fact checked and built in. And we had it for wind and for natural gas. But at that time, 12 years ago, we had decided it needed to be updated. And that update was $20,000. And like, we believed that wind wasn't going to come forward anymore. So we didn't do it. And then wind kept coming, and now we're here. So, I mean, I think that we continue today, here and there, to go back to that guidance document that is, now over 15 years old, and that Excel. I mean, some projects still, that's their base, because they haven't amended since then. And so it's still kind of part, and like that, the depth question, that's built in there, so there are things about reasonable assumptions that our consultant validated that now we've only, if you can go back to this 15-year-old guidance document. Do you have a reference point? So, I mean, I think it's valuable. I think the question for us is, like, can we justify the cost of continuing to update the tool on a frequent basis? And maybe, with AI, things have changed. It wouldn't be that expensive to run an update. We haven't run that question.
Something to consider. I do have one more option before we maybe put a pin in this one, which is, and some other states do this, is that we could use just sort of a fixed amount per whatever. And that really simplifies things. But of course, then you end up with, and that does greatly reduce the cost to prepare the report and for us to review it, because it's just dollars per megawatt. And that's very, very simple and very, very straightforward. And it makes, updating it pretty easy. We could index that to, inflation or whatever. Whoops, go back. But obviously, capacity and acreage may not correlate closely with the actual retirement cost. We will absolutely significantly oversecure on some facilities and undersecure others, or I guess potentially we could double, oversecure some a little and oversecure them a lot, or end up undersecuring some a lot. It would be all over the place. But that, which is to say, like, even if we did option 1, option 2, we still run the risks of oversecuring and undersecuring. So it's not like we could ever eliminate that. But just doing a simple fixed amount per whatever, it does sort of invite inaccuracy. But you would acknowledge that. You're like, we know this isn't going to be accurate, but we're okay with that because it's going to be relatively close and maybe, hopefully, and it will sort of be a wash in the end across multiple projects. But then we would still need to periodically, do technical review and revise this. So it's not like this would save us the trouble of having to do that. But it is done to a certain degree in other places. This approach was done to a much greater degree in the oil and gas industry. There's like standardized at the federal level, and in some states for like, $50,000 a well or something like that. I don't remember the exact number, but this approach is used in other places for certain types of projects. So it's not crazy, but yeah, just going to throw this one out there, and hopefully people will give us sufficient feedback that we can feel comfortable about picking 1, 2, 3, or sort of maybe, some of one, some of another. But that brings me to the next issue, which is sort of where should the mandatory assumptions exist? And one of those could be, and this is sort of related to the other issue of do we have like a standardized format? But we could put this stuff in rule. We could say in rule that you have to, use 3 feet or whatever. You have to include road removal. This is how you would treat contractors, whatever. And that would be very clear. It'd be very obvious when you have a sufficient form. We could just leave that out of rule, and we could just say the rule could say you must submit it in line with department guidance, and we could sort of have just like a technical manual that would be easier to update, wouldn't need to go through rulemaking. But it wouldn't provide the sort of same certainty or enforceability as a rule, and applicants might feel like uncomfortable with the swiftness at which we could sort of change things and how things operated. Yeah, we've had issues with sort of updating tool estimates, and that might apply here as well. And then option 3 would sort of be a hybrid structure of like putting some principles in like minimum cost categories in rule, and then leaving other things like unit costs in sort of that, like a guidebook. Yeah. So I don't necessarily think we'll resolve this right here, but to the extent folks have thoughts about this, add this to your long list of things. This is definitely the most option positive rulemaking that I've ever done, where we've just sort of been awash in options. There's questions. I'm just going to go through this a little quicker, but there's questions about like, who can prepare estimates? Like option 1, like if we were to say basically use department guidance, like that would simplify that. If we weren't to sort of have a department guidance on how estimates are prepared, we could require a certain sort of licensed professional engineer or credential professional. We don't do that right now. A third option would be that we would require independent third-party review that's either sort of selected or approved by council, which again, like everything else, has its own pros and cons that I think are pretty obvious. But this is just something else to consider. One other issue that folks have raised in various realms is the inclusion of automatic administrative overhead. I think it's like 10 and 20%. And I do think that, and which isn't in rule, that's just what we do. So I think maybe establishing fixed percentage, if we're going to do that, if we're going to have fixed percentages, that we should establish them in the rule, perhaps, or some sort of public schedule, so that at least they're known. And then another option would be to require folks, when they're submitting their estimates, to include administrative costs and contingency, because some sort of already do, and then we have just been tacking our own on top of it. So I think it's important for us to sort of not double count administrative costs. So if they're already included in the original estimate, either sort of accounting for that and reducing the estimate for adding ours, or not adding or acknowledging that the administrative costs are already included. So this is one of the few issues that actually has been raised by multiple folks, and I do think it's relevant. I mean, it does ultimately increase the bond amount by like 30%. So I think this is an area where we can and should be sort of accurate to the point that we can be. Chair Condon.
Just a comment about this. There is a risk factor in here that I'm not entirely sure about, but correct me if I'm wrong. If the site certificate holder, we have a bond for a site certificate holder that now chooses to abandon the project or close the facility X number of years in the future, and the bond is not, or the security is not adequate, and we find out that our estimates were not adequate.
Yes.
The LLC is gone, and I know it says the site certificate holder will be responsible. We have language that says that for any overage, but
they don't exist anymore.
They don't exist anymore, and so there is a risk factor there.
Sure.
That I think needs to be calculated. I'm not smart enough to know what that is, but that does leave some question about, nope, there's nobody to cover those increased costs.
Yeah, I mean, I think that's true of this whole standard, right? Like, no matter how you look at it, no matter how you calculate it, you option 1, option 2, option 3, option 4, option 5, there's the risk that the amount won't cover the cost, and there's also the risk that the amount will be wildly, 3 times more than it should have been, right?
Right.
So, and obviously, from a sort of like state-focused perspective, like, well, as long as it covers it, we don't care. But I do think just from a sort of like, fair and reasonable approach, like, we should be as accurate as we can be, but the more sort of like accurate you are, the sort of greater risk that you're going to maybe miss the mark and end up going under. You're lowering your margin of error, right?
Yes. And but I'm just pointing that out, that with all of this, there is no backfill other than this.
Yeah, the bond is it. You're right. And that's
for it.
One of the reasons why these sort of overages I do think exist. But
well, and I don't think we've been trying to have an overage, right?
Yeah, the idea is that these are for the actual administration of the decommissioning, would have to be overseen by somebody, and who's going to pay for that, right? So I do think that's where that cost is intended to address. But
yeah, to administer it, not necessarily pay for it. That's the distinguishing. What I'm trying to distinguish is administrative costs would go for the management of it, but
sure.
now we've got the cost itself. We're under.
Yeah.
So,
David.
Yeah, having some administrative costs, we can talk about numbers, but yes, that's a reasonable ask because you do have to manage it, including what is on your next slide, which is salvage value and et cetera, et cetera. So in other words, it's not just the bond value is the only thing, because there's a bunch of steps beyond. If an LLC goes away, first of all, is you have the asset itself. There's an intrinsic value. You see this all the time in proceedings, bankruptcy proceedings, et cetera, is first it goes to the lender. The lender has to either make whole, and it's only after the lender, if the lender completely pulls out, investors, all those other things, then it goes to mortgagee, and then it goes on down. So the bond is actually is the last. It's not the only, it's simply the last. If all those things fail, then the bond amount needs to be correct. And again, You would also have salvage value and et cetera. And that gets into my other point is about inflation is a funny thing because also often the materials also inflate. And so you actually get more money for your scrap. You look at what's happened over the years, but that goes like a roller coaster. So I think you need to discount salvage value. I'll just tell you right now, I think that needs to be discounted. We'd love to have it exactly precise, as you've said, but the fact of the matter is that you're dealing over, 20, 30, 35 years, right? So those are just my two things is that, yes, a reasonable management of value is good. It's not the only, it's the last. And so salvage value and other things are also inflationary, positive inflation sometimes, not just the more cost. So that's it. As we're going through these selections, just a kind of three statements there.
Okay. Which does bring us to this salvage value slide. So this was previously looked at, I think like 10 years ago or something, some number prior to my term here, 4 years. So, but sort of some semi recently, it wasn't like decades ago, maybe a decade ago, and rejected as too unreliable. And basically, yeah, the value of the material goes up over time on average, but what will the value be at any given moment? Who knows? Will there even be a available recycling facility? I mean, this was an issue with like wind turbines. Like, I mean, what's there? Most wind turbines end up in landfills. So, like, is there a facility that would actually take and be available to recycle the material? I think with solar panels, more likely yes. Certain battery storage, definitely yes. And almost certainly be a recycling facility for batteries, given their sort of high density. But one of the sort of like final issues that's been an issue is, which was sort of touched on by David, is that like, okay, great, there's, the batteries materials are worth X dollars, but because, we can rely on the bond, it goes to the state, like it's guaranteed, but who gets the value of those batteries? Like the states have had issues with, they have to get in line and they aren't necessarily like, yeah, they have a value, but not necessarily going to go to the state to help with decommissioning, right? It might go to another creditor. So like, does the state want to have to deal with that? Some states do. And, but based on my own research, like it's not growing, right? There's a handful of states that do, and the ones that do, some of those in recent years have discounted the scrap value more. Like the trend has been to reduce the scrap value. And yeah, but I don't think it's crazy to make an attempt here. I put it on here. If you want salvage credit, make your best case. If nobody says anything, if no effort is made, my inclination is not to bother. But you can cite other states. You can do your own research. You can say, this is how they do it in Tennessee. We'd like to do something. We think doing something like that is reasonable. I'm just throwing that out there. So shoot your shot on salvage. Chair Condon. Yeah, go for it.
Yeah, actually, that discussion was in my early years on the council.
So that must be like 8 years ago, 7 years ago.
6 years
Yeah.
ago is what it was. And it's just the uncertainty of it, that uncertainty and expertise, actually, that created that. 35 years is a long time,
Sure. So, I mean, I think it's sort of a thing where, like, I mean, I do think it's for wind facilities. I'd be inclined, just my personal inclination based on my research, is to not bother, for solar, maybe. I mean, and I do think there's a very strong case that, like, at no point in the future would a battery installation be worth zero, but would we want to assume that the state would be able to get at that value? That's sort of that's where I ended up. I mean, I was super pro salvage when I first started, but now, I mean, I'm sort of maybe leaning on not bothering, but enough states do it that I think I don't think it's crazy that for us to at least consider it, given sort of the trend to building energy facilities that are maybe have a higher certainty of scrap value. Because this is not just like, steel supports, and steel's probably going to be worth something for, the lifespan of our lifetimes on this earth. I don't know that steel's ever going to be considered worthless, but yeah, David, go ahead.
That's what I'm saying is discounted.
Sure.
Yeah. When compared to, microscopic small amounts of cobalt in batteries, even though that cobalt is worth massive, it takes quite a bit to get it out, and those types of things. But, a wind tower is worth a lot of money and will be likely, but still have some discount. So yeah, I think at least allowing it to have something, a placeholder, and maybe some discussion around its value to offset the cost of the bond. But it needs to be, I think it still needs to be discounted, and I'm coming from it where I want to reduce my bond value, of course, but I also get
Sure.
that
No,
you
I
need
mean,
some
I think it's
certainty.
totally reasonable.
You guys, the state needs some certainty. I agree.
Yeah, and if you have sort of suggestions about how we could maybe secure the value of those assets in a way that would make it increase the certainty that we would be able to get at that, even if it was a discounted value upfront, I think that would be helpful for us to consider. Okay, so right now we are only adjusting right now for inflation. And one option would be, well, one option would be to just keep doing what we're doing, but we could also require recalculation on a fixed schedule. So, every 5 years, I'm just throwing this out there, labor is way cheaper, or labor is way more, or whatever, or we have robots that now dispose of solar in like 2 seconds, and it's way easy, and it's going to be way cheaper than we thought it was going to be. So we should be able to reduce the bond amount. Or I don't know, it could go up and down, right? And so the idea is that rather than just assume, rather than hope that we can accurately predict 40 years from now, we just make our best guess now, and then we update it every 5 years or whatever, so that as we sort of approach the end of the life cycle of the facility, that we're more and more confident that the estimate is an accurate reflection of that amount. The cons of this are that, we may be spinning our wheels and spending time and billing things, and the conclusion is nothing's really changed. So it was like, what's the value of that? It's going to create a recurring cost for certificate holders. So even though we could reduce the bond amount, there's going to be the cost for us to do the calculations to figure out if we should reduce the bond. 5 years, whatever number we pick is going to be too frequent for some facilities and not frequent enough for others. But this is just something to consider. Option 2, and this is what some states, I would say this is the most common other way that other states are doing this. Quite a few states do a graduated bond amount, and many of them do it based on defined milestones. So construction of completion, 1 year of operation, 5 years of operation, 10 years of operation, sort of reflecting the changing risks. Like, at the beginning, 5 years into a facility, I mean, it's presumably it's still fairly valuable. Your solar panels are not going to be suddenly outdated, whatever. Anyway, so this has its own pros and cons that I don't need to get in the weeds on, but I just throwing this out here for the group to consider. And again, if you really like this option and you think it makes a lot of sense, let me know. And then sort of number 3 would be sort of a hybrid where we do, we sort of follow milestones, and then we sort of just have regular intervals. But like this is sort of double work, I guess. But like everything else is sort of like more work, but maybe more accurate. But would that be worth it? I don't know. So in terms of like fully funded, right now we are, yeah, Angela, go for it.
Thanks. So on those 3 options, It seems like
Whoops.
requiring at milestones makes sense because then it's project specific and you're not having, for example, someone that just got their site certificate, but the fixed schedule means they have to require it in they have to update it in 6 months. Like that doesn't make a lot of sense. So you said option 2 was most common in states. Do you have some examples for us to consider about what those milestones are? I mean, you said a few things, but is there a place we can look at specific
Yeah, in
examples
fact,
of
I
what
can maybe
states
just, I think I circulated this report after the previous RAC meeting, but if I didn't, whether I did or I didn't, I'll recirculate it again, but you can kind of go through it, and there are quite a few states that do it. And I think the most common, if just based on my own recollection, it's been a minute since I've looked at the report, is that folks will do like 5 years and then 10 years. They'll, so at 5 years, it'll be like a quarter of the bond amount, or 1 year, it'll be a quarter of the bond amount. 5 years, it'll be like 80%. And then at 10 years, it'll be the full amount, or something like that. But that's sort of two different questions, right? So I may have conflated this myself. So this is the recalculation of costs that is sort of like at various points throughout the life cycle of the thing, we're going to sort of recalculate what we think it will cost to retire. Then there's the second question of when are we going to require you to fully fund the bond? So, which is a separate question entirely. So, because maybe we never change the calculation. We come up with a number and that's the number forever. Okay, great. But are we going to require you to fully fund that on day one? So this is the thing that a lot of other states don't require. They'll have a graduated bond requirement that it's not fully funded on day one, and it will be, it's not even fully funded until, year 5 or year 10 or whatever. That sort of reflects, theoretically the fact that right after a project is built, the likelihood of sort of catastrophic failure such that you'd rip everything out and have to completely start over and, zero value on anything is very, very low. So it's less reasonable to require the full bond amount on day one. A bunch of states require the full bond amount the whole time, just like Oregon does now. So I think this is just another thing where, reasonable minds can disagree. But I do think it's worth considering this approach, especially to the extent that you're less confident in the beginning what the bond amount should even be. You sort of hedge that by not requiring it to be fully funded until farther down the road, which coincidentally, if you're also sort of updating it, would hopefully more accurately reflect what it would actually cost. So it sort of cuts, that risk a little bit. Yeah, I think I could have made this more confusing if I tried, but hopefully people got the distinction between those two. You have the bond calculation amount, which you could periodically update, and you have the fully funded timing, which you could do on a graduated or sort of risk-based or project-based, schedule-based timeline. Okay, so that brings us to this next issue, which is we could sort of move some of the stuff that's in 50 or that you would think that you would want to put in the standard. We could move to Division 25, which is Rule 6 is the mandatory conditions. So, for example, we could add required findings to sort of clarify what you have to submit and how we would evaluate it to the standard. But we could add other things like the stage-specific funding requirements, or liability for actual costs when instruments must be submitted as mandatory conditions. So they're not things that you have to submit prior to obtaining the site certificate. There are things that you'd have to submit prior to operation or construction. Yeah. So, and just as a sneak preview, this is a question that we're sort of weighing heavily on our mind for all our standards that we're going to be reviewing over the next few years is sort of doing a deep dive on, in some cases, should the entire standard be a mandatory condition? But this is definitely as opposed to something that you would need to prove up prior to obtaining a site certificate. Yeah. Okay. Yeah, I think somehow we got to the end and it's 3 o'clock. I'm, to be honest, shocked. I thought we would run out of time. Given that it is 2:43, and we actually have a few minutes, I am going to sort of do a wrap up where I think things should go from here. But before we get to that, does anybody have any thoughts on an issue? I'm gonna go to Andy first, and then we'll go to you, Chair Condon.
Yeah, Tom, I mean, with those of us that are PUC regulated utilities and in the situation where we would be basically mothballing a facility and taking it out of service, our ratepayers would be the ones that would be paying for that. And I would like to see something in these rules that has an indication to that, rather than us having to get a bond that our customers ultimately have to pay for up front when they're going to be paying for it at the end anyway.
Yeah, absolutely. I mean, I'm not necessarily agreeing with you, but I am agreeing that the sort of PUC overlap is something that we should consider as part of updating the standard. And if there are any specific issues like the bond, I would sort of type up your sort of maybe go into some more detail about what you just said, and maybe, yeah, just like a short, like, hey, we're we have to deal with the PUC, and here's why we think that should, we should add something in the rules that accounts for that, and therefore we don't have to do the or compliance with the PUC in this area meets these obligations. So, or whatever it is. Yeah, definitely send that my way.
Will do. Thank you.
Chair Condon.
That was an interesting comment. I was just thinking about, there was a question early in the conversation about LLCs versus corporations and like utilities, and is that a differential we should speak to here because of risk? But two, I'm wondering if another option with respect to changes in the bond amount is, do site certificate holders who have been asked to provide a security instrument, right now, do they have the option to petition and say, hey, our bond amount is not correct, can we recalculate it, other than just calculating for inflation? Is there a process for them to say, hey, things have changed, equipment's gotten, the equipment's different, cost is dramatic?
I don't believe so. Sarah can correct me if I'm wrong, but I think that's something that we should consider. But I do not think is a current part of our process.
Yeah, I mean, the way that it works is we typically write the conditions so that they're locked into the unit costs, and then they're able to adjust the number of components based on final design. So again, you can reduce down based on what's actually built. And in like the last 5 years, we've been trying to build into the condition an allowance for, both the council has the ability to adjust the amount if what you're seeing through compliance is, significant deviation in land management, where maybe, we're questioning the assumptions that went into that estimate. So council has the authority. Sometimes, basically we have some conditions that allow flexibility, but it would be nice if it was built in the rule, because it's sometimes hard to be consistent otherwise. If we want for that amount to be able to be adjusted through certificate holder requests, but otherwise the condition doesn't unless it says that it can be, it doesn't allow it.
Thank you. It just strikes me that that option might be good too. Is that, is there an option that would include that the site certificate holder has the ability to come and say, hey, here's the reason we deserve another look. Or not tied to an amendment and I would imagine they're asking for a decrease. And quite frankly, I think the council or staff should be able to say, hey, things have changed here. Maybe there's an increase. I don't see that
go the other way. Like, yeah,
more, but
you could see it going in both directions.
Yes.
Yeah.
So just a thought. Thanks.
Andy.
Yeah, one more log to throw on the fire here for you, Tom, is
good. This is way too easy.
Yeah. And I'm not sure if this is in consideration for the bonds that we currently have, but we own some of the property that our facilities are on, and wouldn't we be able to determine, does the bond have to cover that because we're the landowner, and determining it being a useful situation after decommissioning would be up to us? And can that piece of property be pulled out of the bond in a situation where you've got other site certificate holders that also own property within their site certificate?
I think maybe Patrick would have to correct me here, but I believe that this has been previously looked at, and that the landowner is actually not allowed to determine what I'm drawing a blank here.
It sounds like the question's been asked before, though.
Yeah, the acceptable. Why can't I think of the magic word? You just said it. The usable state or whatever of the land, functional. Yeah,
functionality or back to a useful state. I think
restore back to a usable state. Yeah, I think there is sort of like an objective standard and I think the idea is that you don't the state values the land, like, especially if it's like, there was this exception made and it's like, farmland or whatever. We don't want the landowner to be like, well, I'm retired. I don't care about how the land's going to be used. So, the developer can be like, here's $100. You agree that we can just leave this as a toxic dump. And then the landowner's like, sounds good to me.
Yeah, sorry. For clarification, I'm talking about the utility. Like, say we actually own property that the facility sits on, and that's what I'm talking about. Yeah. Not from another property owner perspective. I completely understand and agree with that scenario, but there may need to be some consideration. That question asked to the legal team on your side about when the site certificate holder has the property that they own that's in the site certificate, does that need to be included in the bond total?
My inclination is that the answer is yes, but I definitely will follow up on that.
Okay, thank you.
Yep. Okay, so this is where I was going to reserve some time for the public. We had some folks who I didn't recognize, but they have since departed, and everyone else here is, I believe, on the RAC. So I'm going to move us to next steps here. My goal is to actually start producing some draft language based on today's discussion, and some hopefully critical, I would say more so than any other rulemaking I've ever done. It would be helpful to get RAC feedback on, as you can see, the many options that we're going to have to sort of figure out and navigate. If people need more time than this, let me know, but I'm hoping that folks can get back to me by September 18th, which is basically 3 weeks from tomorrow. And then I would then take that feedback to then produce draft language. I don't necessarily know that we will have another RAC. We might. I think it sort of depends on the feedback that I get. Like if the feedback is sort of all the same-ish, there's not like a variety of opinions, then I don't necessarily know that'd be helpful to have another RAC. Regardless of whether we have another RAC, I will circulate that draft language prior and allow for additional feedback before going to the council. So if we don't have another RAC, say I get this feedback by September 18th, I produce some draft language by October. If I would still wait to hold to go to council before circulating that draft language and then having people provide feedback on that. So, but if there was another RAC meeting, it would probably take place in October, because I'm going to try to generate some draft language pretty quickly so we can get this rulemaking wrapped up. Does anybody have any questions about this, about next steps and what the approach we're going to take? Okay. I'm going to make this presentation available on the rulemaking webpage, just under the FAQ documents. You can just go there, download it, and see all of the topics and options and whatnot. And then I'm also working on the sort of master document that I use to sort of generate this. I'm going to try to make it like public facing ready so that you can maybe refer to that. It'll probably be easier to navigate than just like a PowerPoint with a bunch of slides. And then you can use that to provide your feedback. Woo! This is a lot. So I appreciate everybody staying with us for the last 2 hours. Chair Condon, hand up.
Hey,
Yes.
what are you going to include the material about the different states and what they're doing?
Oh, yeah. I'll actually put that on the FAQ page as well. So when you click on I'll send the link around, but it's just the rulemaking page for this rulemaking. I'll have them upload that 50 state review. Just put it there for people to, members of the public, anybody can go. We'll see that.
Yeah, I think it is.
And I'm not endorsing that. Like, I don't know how. I mean, I assume it's relatively accurate. I mean, some of the ones I looked into seemed accurate, but it certainly, I found it useful.
Yeah, I think it'd be interesting as background information. Whether we do any of it is questionable, but yeah, thank you very much.
All right. With that, I will let you all go 5 minutes early.
Thank you, Tom.
Thanks, Tom. Great job.
Thanks.
Yeah. Thanks, everyone. Sorry I was late.
No worries.